My name is Ryan Meikle. I'm a partner with Holden Kidwell, Hunt & Crapo in Idaho Falls. Prior to joining Holden Kidwell, I spent 4 years with a national law firm in the Midwest, and we did exclusively mergers and acquisitions, primarily for publicly traded trucking companies and several venture capital firms in doing their roll-up acquisitions. My first firm that I worked at, we focused on the mergers and acquisitions, and it was really a national-based practice. Our law offices were located in Lincoln, Nebraska, which is interesting because we didn't have a single client located in the state of Nebraska. Our clients were located throughout the entire United States. In our practice, we had 13 attorneys in the firm, and we all did the exact same thing. We only did mergers and acquisitions. No one did any litigation, no one did real estate, no one did employment contracts. We did solely mergers and acquisitions is all we did, all 13 attorneys. Our clients were located, like I said, throughout the United States. We were competing with law firms that were on the coast. Most of our clients were used to using New York law firms or California-based law firms. So we competed with them based on our experience and our rates. We had an experience that was equal to these large law firms because of the volume of the work that we did and the type of attorneys we brought in. But our rates were much lower than these New York firms. So we weren't really even able to compete in our local market because our rates were so much higher than the local rates, but were much lower than these national rates, and so we became a good fit for these clients. The other piece with our clients that we experienced was, if we did, this normal deal size was between $3 million and $100 million. Well, a $3 million deal to a large law firm in New York is a very small deal. To our law firm, that was kind of a bread and butter deal. And so our clients, we were able to give them much better service, be much more responsive than the large law firms who were used to doing a $50 million or $100 million deal was a good deal to them. And so they didn't quite get as good a service as they did from these large law firms. So we competed on service and then on rates when I was in Lincoln, Nebraska. Moving back home to Idaho Falls, our law firm is a general practice law firm. And although the firm is a general practice, each attorney or partner specializes in a certain area of the law. So we have attorneys that practice in every area, whether it's criminal, family law, estate planning, real estate law, commercial litigation, and then business transaction, for example. But each partner focuses in a specific area. So although we provide all those services, I only provide transaction-related work or estate planning. If there's any other type of work that comes into the firm, I refer that to one of my other partners. The type of clients or businesses that we worked for in Lincoln, Nebraska, kind of that national firm, were mainly publicly traded companies. So these were large companies, large organizations, and they were trying to grow their business through acquisitions. Since they were publicly traded companies, there was no way for them to meet their earning goals through internal growth. So basically every quarter, each one of these clients was trying to acquire another business. It's interesting the way we found clients in Lincoln, Nebraska when we're dealing with these large publicly traded companies. We would find companies that we thought we could provide representation for, which would basically be another publicly traded trucking company, for example. And we would try to make contact with someone at that firm. Typically, it would be the chief financial officer or the chief executive officer. And we would try to make contact with them. We would let them know that we were going to be in their city and that we would like to meet with them. So we would arrange a lunch or a dinner, and a couple of us would go and we would meet with them, and we would have a presentation or a power deck that we would give to them, and we would go through and talk about the transactions that we had worked on so they could see that it was similar to the industry they were in and their needs. And then we would show basically our expertise and the services we provide, and then we would always talk about the cost. If I take that same experience to Idaho Falls and how do I get clients, I'm not traveling all over the country trying to find clients. I'm doing more of a local, regional-based practice. But at the same time, there are certain people I try to make contact with and let them know if they're a business owner and I recognize I can provide value to them. I have made phone calls. I have found an opportunity to be introduced to certain people to to be able to explain my practice and how I could represent them. You know, it's interesting when you're talking about how do clients decide if they're going to use you based on your skill set. Well, these large publicly traded companies, they have a lot of law firms. And they're sophisticated and knowledgeable about the resources, exactly what they're looking for. So we provided just mergers and acquisition related work in Lincoln, Nebraska. Well, these firms had all kinds of legal needs. They needed someone to do their employment contracts. They needed someone to do their commercial litigation. So we filled a very specific need, and they were looking for a law firm that could do just that piece of their business. And that's what we sold ourselves on. Well, back in Idaho Falls, most of my clients aren't extremely sophisticated. Certainly I have a lot of sophisticated clients, but when you're dealing with an entrepreneur or just a small business owner, they don't necessarily have a lot of ongoing legal needs, and they don't necessarily know what all those legal options are. So frequently they'll call and just say, I need project X done. I have a lawsuit I need. And then I'll be able to tell them, well, I don't do that type of work. And then I educate them, well, here's the type of work I do, but here's the work my partner does. So we do a lot more educating of clients locally on the type of law or the practices areas that there are, so that they can get an appreciation for exactly who they're looking for. It's interesting when someone comes to our firm, depending on what kind of legal services they need, there's someone in my firm that can provide that service with a high level of expertise. Typically, if an entrepreneur comes to my firm and they need employment-related law, for example, I have a partner that does just solely employment law, and so I refer them to that individual. So I think it's important when an entrepreneur is starting a business, if you have a need and you recognize a need, when you call the attorney's office, make sure they have that type of experience, because I think you'll get much better service and you're going to get it at a more efficient rate. If the attorney focuses in that area, they know exactly your issues, and they're going to be able to probably do it at a cheaper rate for you or expense because of the number of hours they're going to have to spend. My experience is if you call a general practice attorney who today they're going to do your divorce and tomorrow they're going to do your estate plan and the next day they're going to set up your business and then 2 years from now they're going to help sell your business, it's hard to be an expert in all of those areas. And so in my experience, entrepreneurs are better served in finding someone who has expertise in exactly what their need is at that given moment. And whether that can be found in multiple firms, that's fine, whether you can find that in all in one firm. But I think it's rare that you would find one attorney that has all of the expertise that you would need. And I think it's important when you're first establishing an attorney-client relationship and you're looking for an attorney, that should be one of the questions you're asking is, how do you charge? When do you bill? How do I know how much you're charging me at any given time? And so you can clarify that relationship right at the beginning. And people shouldn't be afraid to talk about that. It's a real important part of the representation. So in my practice, I have several different fee models depending on the type of client I'm working with. If I'm doing an estate planning project, I will meet with a client for no charge because initially I have no idea what needs they have. And so it's hard for me to quote someone a fee and say, here's how much it's going to cost, without sitting down and talking to them about their needs. And that's similar with business clients. The initial consultation is usually free because we're identifying the scope of the project. So at the end of that initial consultation, take for an estate planning project, for example, we'll have identified exactly what documents the client needs. And at the end of that meeting, I'll be able to quote them a fee for doing the work for that project. If they then engage me to do the project, well, my time is captured in that fee. If they decide not to use me, then there's no charge. Similarly, when a business client comes in and I don't have an ongoing relationship with them, it's the same thing. We'll sit down and we'll be able to visit about the scope of the project, what their needs are, whether I have the expertise and can help them in that arrangement. Typically with my business clients, it's an hourly rate, so I then quote them an hourly fee for the project. I try to give them an estimation of the amount of time that will be spent on the project, but that's always difficult because it's really hard in a business transaction to know exactly what fees will be incurred. And then they can decide whether or not they're going to use me. But again, there's no charge if they don't use me. When I'm dealing with an entrepreneur that's setting up a business, well, again, that's more like the estate planning context. It's a very discrete project. I know exactly the scope of the project. And again, I quote a specific fee for setting up the business and getting their business formed. So a lot of times entrepreneurs talk about a contingency fee. You hear this term a lot, and they want to know if I'll work on a contingency basis. Typically, contingency fee arrangements are litigation-based. They're involved when there's some type of dollar amount that is going to be received by the client. So litigation, they're suing someone and they're expecting to get a monetary award. And so someone would be willing to take on a contingency fee, or it's an arrangement where the attorney agrees to take a percentage of whatever the client receives in damages or is awarded. So that's more in a litigation context. But clearly I have an interest in developing long-term relationships with clients, so there are cases when I'm willing to do that. Or it's just generally I'm trying to help this economy grow. I want to see this area grow and develop. And so, you can find attorneys who are willing to help you. Now, I wouldn't go into an arrangement expecting a client to work for free. The entrepreneur is not going to sell their product for free because they won't be able to succeed, as a business. if they give away their services, and it's no different than an attorney. And so entrepreneurs shouldn't expect an attorney to provide free services to them, because otherwise the attorney won't have a business model that succeeds. But you can find ongoing relationships and find opportunities where attorneys will be willing to help and assist, maybe guide, give you some general advice. You know, if a client calls and it's clearly something that they can do on their own, I have no problem saying, hey, here's the form, go to this website, download it, fill it out, send it in, pay the fee, and you're set. You don't need to pay me to do that. Clients will frequently ask me, what can I do to work with you better or more efficiently so I can save on the legal fees? And you know, that's a great response, and it's always a balance we're trying to figure out with any given client. But I think there's two very specific ways they can do it, and that's not call the attorney too soon in transaction and not call them too late in the deal. In either scenario, you're going to incur additional legal costs, and that's a tough balance to find. And you know, you can call an attorney and talk to them about where you're at in the project and if it's time to engage them or not. And a good attorney is going to say, hey, you know what, go figure out some more of this and then get me engaged. Or, yeah, you know what, you should have got me engaged a little bit earlier. And as you go through and you start working more with attorneys, you kind of find that balance. So for example, if a client calls me and says, I'm selling my business, okay, great, who are you selling it to? Well, I'm not really sure. Okay, how much are you selling it for? Well, I'm not really sure, but prepare the contract. Well, there's not a contract I can prepare. Or a lot of times they know who they're selling it to and they know the price, and they'll say prepare the contract. But they haven't spent the time negotiating a lot of the terms, and so I prepare a contract and then the deal changes. That increases the cost because I'm redoing the contract a lot. And so additional costs are incurred because they involved me too early in the project. The client will get done negotiating the entire deal, they're ready to sign the transaction, and then they send it to me and say, hey, I have this deal, we're going to close it tomorrow. We just review it and let me know if there's anything major problems with it. That increases their cost. And a lot of times it'll blow up their entire transaction because there are major legal considerations that they should have thought about. But at this point, it's too late to go back and try to renegotiate those issues, and it can cause major conflict. Or if they do, the whole document's been structured the wrong way. And so again, they've now doubled the legal costs that they otherwise would have had if they got us involved at the right stage.